This is a reviewer for public international law, specifically the subjects of international law covering international organizations. So, the definition of an international organization is that in order to qualify as an international organization, an entity must be composed predominantly of states and or other international organizations, and it has to be established under international law. International organizations usually come into being by means of a treaty. However, they can also be created by other means, such as through a resolution issued by another international organization, or when states enter into joint unilateral acts. Additionally, an entity that is an international organization has to possess autonomous organs that have a will that is separate from that of the members. So even though an international organization must be composed predominantly of states and or other international organizations, the organs of the new international organization have to be separate and have their own will separate from that of the members. So, what does this mean in practice? This means that an organization would have a separate legal personality. So, that is why it can be a subject of international law, and it must be able to act on a majority basis. What is the difference between an international organization and an international NGO or non governmental organization? When distinguishing between international organizations and INGOs, the composition really is what you look at. So the former international organizations and other intergovernmental organizations would be primarily composed of states. Okay? The composition is predominantly states. Whereas INGOs, they would be primarily composed of private entities. However, they could operate in more than one country. So the members of an INGO would be private entities, but they would operate in more than one country, hence giving them an international presence. But that doesn't make them international organizations nor intergovernmental organizations. Now, what is the difference between an international organization and an international public corporation? So, international public corporations, or they can also be joint interstate enterprises. That's another term for it. International public corporations or joint interstate enterprises. These are entities which are created jointly by a number of states. So a number of states come together, they join together, and they create some public entity for the purpose of performance of commercial functions. So international public corporations, it is still some joint efforts, some collaboration between states themselves. However, the purpose of this entity is for commercial functions. While international organizations are entities that are created under international law and have international legal personality, joint interstate enterprises or international public corporations are formally established under the corporate law of one of the member states. So what gives life to these international public corporations? The municipal law of one of the member states, one of the states that joins together to form this interstate enterprise. Their municipal law, which governs the formation of corporations, would be what gives life or existence to this joint interstate enterprise or international public corporation. Okay? So, even though this enterprise, you could trace it back to a treaty because that could be the basis of the joint effort or why these states are collaborating. Really, it's not that treaty which created the international public corporation. It would actually be the municipal law governing corporations in one of the states. Now, as to membership in international organizations, there can be variations. So it could be universal membership, it could be open to everyone, or it could be closed membership because it's a regional, it's a regional international organization. So the membership would be limited to those states which, or other international organizations which belong in that geographic region or have some relevance to that region. International organizations that are universal in their membership are open to all states, and an example would include the United Nations and its specialized agencies. Closed organizations would limit membership to states which fulfill certain common criteria. Now, membership and function can be combined in various ways. So there can be closed regional organizations that exercise general functions, or there could be universal organizations, so universal as to their membership, but as to their function, their competence is limited only to a specific field. So narrow function, but universal membership. Okay. Now, as to the legal personality of international organizations, when do you say that an entity has international legal personality? You say this when the entity is a bearer of some rights and duties that are derived from international law. International legal personality is indicated by the fact that this entity can bear rights and duties, and these are derived from international law. Some constituent treaties expressly provide for the legal personality of the organization. So, when creating the international organization, the treaty which created it provided that, yes, it has expressly, it says, it has legal personality, international legal personality. Some constituent treaties, however, are not expressed in their wording, okay? So, if there's no express treaty basis, international personality can instead be deduced by other means such as the inductive and objective approaches. So, if you have international legal personality, you are able to have some rights and some duties derived from international law. What would be the consequences? The possession of legal personality would distinguish the collective entity or the organization from its members. They would have a separate legal personality from the constituent members. The second is that the personality would entitle the organization to bring a claim in international law for the purpose of maintaining its own rights. So the international organization possessing its own rights in its own name, or in its own name, can then bring a claim to enforce those rights in international law. And lastly, personality entails the consequence that an international organization can then be held responsible or liable in case it does not fulfill any of its obligations under international law. So, because it can possess rights, it can bring a claim if these rights are violated, and because it can possess duties, it would obviously be held responsible for non-fulfillment of these obligations. And this personality gives rise to a presumption that the members of the organization are not liable with respect to the obligations of the organization, although this presumption is disputable. Okay, this presumption can be displaced. And there can be situations where the members of the international organization, the states themselves, can be held liable for the obligations of the organization. Okay? So it sounds very, very similar to the municipal law concept of corporations. Now, or the separate legal personality of corporations. It sounds similar. So if you're familiar with that, it should be easy peasy. But just put it in the international law context. And you don't have stockholders, you have member states. Other consequences of having a legal personality in international law, so an international legal personality, would be that, so this international organization still has to be hosted somewhere, right? You have to have offices, you have to have people working for it. They have to have some sort of physical location, probably, right? Likely. I don't know if there can be one entirely online now. Maybe for like offices, but still operations. There would have to be some actual geographic location for these operations, right? So at least within the host state, another consequence is that at least within the host state, custom would confer certain privileges and immunities on international organizations. So customary international law gives some privileges and some immunities to international organizations operating within a state. So the host state has to confer these privileges and immunities upon the international organization so long as they're operating there. And why is why? Why is the purpose? What is the purpose of this? Because it would be necessary for the efficient and independent functioning of the organization. So the state would essentially be cordial, play nice, be a good host. And then another consequence is that international organizations would possess a power to conclude agreements which are subject to the law of treaties. So international organizations can conclude agreements, and the governing law for these agreements would be the law of treaties. International organizations, where the membership would consist of a vast majority of the international community. So the UN. So pretty much a majority of the states, the international community, they are members of the United Nations. And this gives rise to an objective international personality. Okay? Objective international personality. Majority of states belonging to an international organization gives rise to an objective international personality. What is the consequence of an objective international personality? The personality can be opposed to or challenged even by non-members. So if a majority of states belong to one international organization, this gives rise to an objective international personality, and the consequence of this is that the personality is opposable even to non-members. Now, since international organizations also operate within the territory of the state, they would also need to possess a domestic legal personality. So they have an international legal personality. They can possess rights and duties. They can have rights and duties under international law, but because they have to operate essentially within a state, within that state, they also need to have domestic legal personality. Why? So that they can actually perform legal acts in that country that are legal under domestic law. So even in the absence of any express treaty obligation, there would then be an implied obligation for the members of an international organization to provide the organization with such domestic capacities as are necessary to allow for it to function effectively. So even if the treaty, which brings together all the states that will be members of this international organization that they're forming, even if that treaty doesn't say that, okay, there's an obligation upon every state to allow this international organization to essentially effectively operate within your state, and you do this through how giving it domestic legal personality, it's implied, because how else will it get done? Moving on. Now, the constituent instruments that give life, that make international organizations. So the constituent instruments of international organizations. How do we interpret these? Now, a constituent instrument, whoa, that's giving, it's a tongue twister for me for some reason. The constituent instrument would set out the following for the organization. First, the purpose, the structure, and the competencies of the organization as a whole. So it would give, purpose, structure, competency, organization as a whole. Then it would also give the particular powers and the particular functions which would be granted to the individual organs of the international organization. So the international organization as a whole, and then it also has its separate organs. And then the constituent instrument would also set out the position of the organization vis-a-vis its members, the relationship between the individual organs of the international organization, the rights and obligations between the members, the relationship between the organization and third parties. So essentially, the structure, what is this international organization? That is what the constituent instrument is going to tell you. What is it? How does it exist? How does it function? Who is it in relation to all of the other actors that it would have relationships with? And then who could interpret these constituent instruments? So you execute these instruments, gives rise to the international organization. In case of ambiguity, who may interpret these instruments? They could be interpreted by, first, the organ itself. So it can have some self-reflection there. Second, it could be judicial or arbitral tribunals. Or third, national courts. So the organ itself, so the international organization itself, or its organ, can look at its own constituent instrument. Second, judicial or arbitral tribunals can look at the constituent instrument and interpret it. And third, even national courts are empowered to interpret constituent instruments. Now, there are two principles here to remember in the interpretation of constituent instruments. The first being the principle of effectiveness. While the general rule is that interpretation must be based above all on the text of the treaty or constituent instrument, special prominence is given to the objects and purposes of constituent treaties of international organizations. Again, the principle of effectiveness states, while the general rule is that interpretation must be based above all on the text of the treaty, special prominence is given to the objects and to the purposes laid out in constituent treaties of international organizations. Okay, object, purpose. Look at that first. Then you have the concept of subsequent practice. The practice of the organization is often given a special role in the interpretation of constituent instruments. So the practice of the organization is used not only in cases where there is some ambiguity existing in the text of the agreement itself, but also in cases of silence and when there's a need to craft new rules and tack these on to the constituent instruments. So it's important to look at the actual practice of the organization when interpreting the text, when interpreting silence, and when crafting new rules. Okay. So we've talked about the legal personality, we've talked about the interpretation of constituent instruments, and now let's talk about the powers of international organizations. So two concepts or two doctrines sort of to remember here. Actually, one doctrine, one concept. So first is the doctrine of implied powers. Here, an organization is deemed to have those powers that are necessary for achieving its purposes, even in the absence of words in the text which indicate that the organization is to have such power. Implied powers are not restricted to those powers which are necessary for carrying out the express powers or functions. So, there is an implication for international organizations that it would have the powers that are necessary for it to achieve its purposes in the absence or in the silence of words in the text that would actually grant these powers. There's a necessary implication that these powers exist, because how else otherwise would the international organization actually perform its functions or achieve its purposes, okay? And these implied powers are not restricted to those powers which are only necessary for carrying out the express powers or functions. So it's not, okay, what are the powers of the organization? We have the ones that are listed down in the text. Those are the express ones. And then the implied ones would only be the ones that would support the express powers. No, the implied powers are the ones that are necessary to achieve the purpose of the organization as a whole, not just the express powers or functions. Okay? The second thing to discuss is decision-making powers. In determining whether or not a particular decision of an international organization is legally binding on its addressee. So what we're asking here is, as to the decision-making powers of an international organization, how binding is this on the person who, or the subject of that decision, okay? First, consider whether the organ or organization is empowered by its constitution, either expressly or impliedly, to make binding decisions. So, does it even have the power to make decisions? Was it granted this power either through express provision, or is it implied necessarily from its ultimate purpose? So, the second question is whether the language of the decision reveals an intention of the organ or on the part of the organ to issue a binding decision. So first thing you look at is whether or not the organ or organization even has the power to do this. Second, you look at the text of the decision and you see whether or not the organ was trying to bind with it. Okay? So since international organizations, however, they do not generally have lawmaking powers, it would be rare. That is an exception. Generally, international organizations do not have lawmaking powers. What they are given in lieu of lawmaking powers is the power to make non-binding decisions, which, okay, here you go, consolation prize. Do with that what you will, play with your stick. No, I'm kidding. Okay. So international organizations generally do not have lawmaking powers, and instead they are given the power to make non-binding decisions. And how would you come across these? What forms would they take? Recommendations, determinations, declarations. So these are non-binding decisions issued by international organizations. So just remember, non-binding. But also remember that non-binding in international law does not mean that they are devoid of legal effect. Just because they're non-binding does not mean that they are completely hollow and empty. So even though states would not be bound by recommendations, by determinations, and by declarations, the issuance of these decisions still does have legal effect in international law. Next, the privileges and immunities of international organizations. So we're going to talk about immunity from jurisdiction, immunity from execution, the inviolability of premises, currency and fiscal privileges, and freedom of communication. And I think this is the last one for international organizations before we go on to individuals as subjects of international law, which will then lead into like diplomatic immunities and stuff. Okay, whatever. Let's finish this. Okay, privileges and immunities. So the scope of the privileges and immunities granted to international organizations. Remember, we mentioned this a little bit earlier before in that the host state, which the host state is supposed to grant certain privileges and immunities on international organizations, and these are the ones that are necessary so that the international organization would be able to efficiently and independently function. And this obligation upon the state to give these certain privileges and immunities to the international organization is through custom. So it's customary international law, and it's also a consequence of the international organization properly being organized under international law, so then it can be a subject of it, and customary law would kick in. Boom, they have these rights and privileges. Does it make sense? It's all connecting. It's a circle. Now, okay. The first would be immunity from jurisdiction. So international organizations are usually granted absolute immunity from the judicial jurisdiction of states. So domestic courts generally do not have jurisdiction over international organizations. Why? Because you don't want the organizations to be bogged down by lawsuits in domestic courts. It would be very difficult for them to perform their mandate, to perform their function, to achieve their purpose if they would be tied down in domestic courts. So there is an immunity from jurisdiction generally granted to international organizations. And this immunity from jurisdiction is absolute, okay? It is absolute. It would prevent any lawsuits against organizations before domestic courts. But however, the immunity can still be waived. So the international organization generally granted absolute immunity from judicial jurisdiction of the states. However, they can waive this immunity by consenting to participating in the proceedings before domestic courts. Next, you have immunity from execution. So domestic legal systems would not be able to seize or to execute against or to attach the property and other assets of international organizations. So this immunity from execution would prevent the seizure or even prejudgment attachment of the property and other assets of the international organization. It follows from the immunity from jurisdiction. It just makes sense. Third, the inviolability of premises. So the premises of the international organization are to be inviolable, and its property and assets are to be immune from search, requisition, confiscation, and other forms of interference by state authorities. So there is what's being fleshed out here, or what's becoming quite obvious, is the sort of independence, or the due regard that is the level of due regard that is given to international organizations operating within a state vis-a-vis that state itself. So the level of interference, I would say, interference, or regulation, like how much can that state step into or impose upon that international organization? It seems very little, because again, they consented to be members. They're hosting them, so they're being good hosts and respecting the international organization's premises, their properties, their immunity from jurisdiction. Okay? So the premises of international organizations are to be inviolable, and its properties and its assets are immune from search, requisition, confiscation, and other forms of interference by state authorities. So, immunity from search, immunity from interference by state authorities for the property and assets of the international organization. The inviolability of premises also means that the premises are inviolable. And another thing here is that the archives of an international organization, so the documents, right? So they're archival documents. They are usually inviolable wherever located. So what to remember for inviolability of premises? First, premises are to be inviolable. It's in the name. Second, property and assets are immune from search or any other forms of interference by the state authorities. And lastly, archives of the international organization, so these documents of the international organization, are inviolable wherever located. Last two things to discuss here: currency and fiscal privileges. So the transactions entered into by international organizations should be free from financial restrictions. So what does this mean practically? How does this operate? They're usually exempt from direct taxation on their assets, on their income, and their property. So if you look at, say, the UN, how it operates in the Philippines, they aren't really levied upon with any taxes. I should know. But so they're granted exception, or they're granted privileges with regards to taxes on their properties, their assets, okay? And then also assets, income, property, usually exempt from any direct taxation there, okay? And then also customs duties and other import and export restrictions with respect for any articles for their official use. So this is just a general privilege, fiscal and currency privilege granted to international organizations. So you're operating in our state, that's fine. We won't tax you for bringing in stuff. We won't tax you for owning stuff. We won't tax you for your income, if any. And we won't tax you for the privilege of owning property. Then the last one is freedom of communication. Official communications by international organizations shall be accorded treatment at least as favorable as those accorded to foreign governments. And what does this mean? No censorship. Okay, and I think that is it for international organizations as subjects of international law. Okay, bye.